Insurance professionals work hard every day to keep people safe. But as technology transforms the industry, how can insurers protect not only their clients, but also shield themselves from ever-changing cyber risks? My name's Elizabeth Blossfield, and I'm the host of the Insuring Cyber Podcast, a bi-monthly look into how the world of cyber and the business of insurance are connected. Does everyone listening to this podcast remember video rental stores like Blockbuster? Maybe that reference takes you back to a simpler time. It certainly does for me. But on today's episode of the Insuring Cyber Podcast, we're going to be nostalgic about video rental stores in a different way. We're talking about Blockbuster-Era legislation and how a 1988 law regarding video rentals is still affecting the legal and even the insurance and technology landscape today. The Video Privacy Protection Act was enacted in 1988 after Judge and U.S. Supreme Court nominee Robert Bork found that a list of 146 videotapes he had rented over the course of 2 years were leaked by a video rental store clerk, the Harvard Law Review reports. Although the Bork tapes, as they've been called, didn't reveal anything harmful or unsavory, it spurred a debate about the importance of intellectual privacy. The VPPA initially served to restrict the disclosure of video rental records without the watcher's consent, although it's now being used to do much more than that. A recent spike in lawsuits alleges that websites running the Pixel code from Meta, formerly Facebook, are violating the VPPA by sharing information about visitors' video viewing habits and history back to Meta. Under these lawsuits, the definition of a business that delivers audio-visual materials has been adapted to apply to modern technology like video streaming services or websites with video capabilities. According to Meta's website, the Meta Pixel is a snippet of JavaScript code that allows users to track visitor activity on their website. The latest wave of VPPA claims alleges that use of the code results in disclosing private consumer information to Meta, violating the VPPA. Claims have been brought against a variety of businesses, including news outlets, streaming services, and e-commerce companies. The Insuring Cyber Podcast reached out to Meta and did not receive a comment by press time, but I am talking to two guests who are going to break this all down for me, including what it means for the litigation landscape and for insurers. First, I'm speaking with Antonio Trotta, Vice President and Claims Practice Leader for Cyber, Professional Liability, and Financial Lines at QBE North America. Tony has 20 years of experience handling and advising on claims involving management and professional liability insurance coverage. He spoke with me about how costs regarding VPPA claims could add up for insurers and what could change about data privacy laws moving forward. Check out our conversation. Hi, Tony. It's great to be speaking with you today. How are you doing?
Good. How are you?
I'm doing really well. Yeah, thanks for taking the time to do this. I'm really looking forward to our conversation. I was wondering if you could just sort of start off by giving an overview of your background and how you got into insurance as well as your role at QBE.
Sure. It's so funny that you mentioned that because I used to have a friend of mine who said nobody actually goes into insurance thinking they want to go into insurance. If insurance just kind of finds you, which is actually kind of right. So prior to doing what I do now, I was a litigation attorney for 6 years, and my practice mainly focused on insurance coverage disputes involving crime and E&O and media policies. But I've also had a hand in securities litigation and bankruptcy litigation at points in times during my career as an attorney. In 2001, I was offered an in-house position at CNA, and I was with their commercial crime team, but then I quickly moved into their E&O team in 2003. And cyber and privacy litigation grew out of E&O policies. So it's been an interesting ride to see the developments in this space in the last 20 years.
Yeah, it definitely has. Even in the last 5 years, I feel like so much has changed, especially regarding cybersecurity. So that sounds like you have great background, and I'm really looking forward to speaking with you today. I know, we're talking about some litigation that's emerged as a result of the 1988 Video Privacy Protection Act. So I was curious if you could briefly explain what the VPPA actually is and the reason it was initially enacted.
Sure. So the VPPA, it's a statute that's designed to protect consumers from having their identities in the video content that they purchase, rent, or view shared with third parties without their knowledge or consent. As you mentioned, it was 1988. It resulted when Robert Bork, who at the time was a candidate for the U.S. Supreme Court, was before the U.S. Senate during his confirmation hearings. And at that time, one of the members of the committee asked him questions, like pulled out a list and asked him questions about his Blockbuster video rentals, which he had been able to obtain. They were innocuous, but at the same time, it caused some concern among some of the more conservative folks within the House and the Senate, and they enacted the VPPA. And the VPPA, the thing about it is it carries that hefty civil remedy of $2,500 for violations of the statute.
Yeah, that's great background about what it actually is. And Blockbuster is such a throwback.
One of the things I should mention about the VPPA, right, is it was originally, when it was drafted, it was designed to cover videotape service providers, right? So it was limited to like really hard physical media. But in 2010, the Obama administration amended the statute to include electronic data as well.
Okay, yeah, that makes a lot of sense. And I definitely want to get back to that a little bit later in the conversation. But, I was curious. I know there's been sort of a recent wave of lawsuits regarding alleged violations of the VPPA. I was curious what you think has led to this recent wave of litigation.
Right. So this most recent wave is really resulting from how companies are deploying ad technology across their web and mobile platforms. The main target, the main technology that's been alleged in these recent suits is Facebook Pixel. And I'll describe that very briefly so that people can understand what's really at issue in terms of what's going on. So the Facebook Pixel is something that when you subscribe to Facebook on your PC or on your Mac, and you click to agree to their terms of use, they embed something called a C user cookie on your device, on your machine. And that cookie has it interacts with other cookies like a Facebook Pixel that can be placed on various websites. And a lot of companies use the Facebook Pixel because it really creates, it's an interesting tool that creates metrics about how certain demographics interact with your site, what they're viewing, what they're buying, what they're looking at. And the company that uses a Facebook Pixel, Facebook sells that to the company, and the company can go back to Facebook and essentially get a dashboard of various metrics that are helpful for their marketing departments to be able to craft campaigns to win new subscribers or to see how, what kind of content they may want to develop in the future. So in terms of the technical application of the Pixel, what it does is when you visit a website that contains a Facebook Pixel, the Facebook Pixel essentially talks to the C user cookie on the visitor's machine and says, I'm here, and here's some of the information that you can pull from this site. And for the purposes of the VPPA, it's video information, right? So it's what kind of video information or video is the user looking at on that website. The Pixel, however, can do a lot more than that, right? So keep that in mind. It has a broader metric of collecting and sharing data. But essentially what it does is it pushes that information down into the C user cookie. And it's the C user cookie from the visitor's machine that's actually sharing that information back to Facebook with something called a Facebook ID, right? So the Facebook ID of the user gets transmitted back to Facebook along with the information that's pulled off of the site from the C user cookie that the Pixel allows. And the reason that's important, and we can get to it later, is because technically the company using the Facebook Pixel is not communicating with Facebook, right? It's the visitor's website. It's the visitor's machine that's pulling the information from the website and sharing it back to Facebook.
Oh, okay. That's interesting. Yeah. So these companies need to really be thinking about that, if that's something that they're using. And, I'm curious also with insurers in particular, what are some of the concerns for them regarding this litigation? Could they be on the hook for any of the costs of these settlements?
Yes. And it's a huge concern. The real concern is this. So the VPPA, as I mentioned before, it has a statutory remedy of liquidated damages of not less than $2,500 per violation, right? When you're dealing with electronic media and electronic communication, and let's say you're a streamer, right? A big streaming company, and you have tens of millions of people as a subscriber base, if not hundreds of millions of people. And many of those people are viewing through internet websites, right? I know a lot of people go on their TVs, their smart TVs and other devices, which, by the way, may not employ the Facebook pixel. They may employ other types of mobile ad technology that works similar, but for purposes of this conversation, let's keep it to the Facebook pixel. So you have a subset of your subscribers that interact with their PCs and their Macs. And that could be millions of people. Honestly, it could be millions of people. Times that by the 2,500 that you have, right? And you're looking at exposures that can run into the billions of dollars. True exposures, right? For some very large players out there. But even if you're a smaller player, those numbers can add up pretty quickly.
Yeah, that sounds like a big concern for insurers. And, the other thing I was thinking about is I know that insurers collect consumer data as well, especially in insurtech where a lot of insurance transactions are taking place online. Should insurers using this technology be concerned about their own violations of the VPPA at all?
Well, I'll just say that anyone using mobile ad technology, be it Facebook Pixel or any other type of collection technology or sharing technology, should have robust procedures around whether or not it complies with legal obligations. Now, in terms of the VPPA specifically, I don't think insurers are the real risk targets here. And the reason is VPPA is a video statute, right? Insurers are usually not in the habit of streaming video content. I'm not saying that some of their websites don't have video content, but generally you're going to see that their bread and butter isn't video distribution. However, there's another reason is the statute really only applies to consumers. And a consumer, there is some debate as to what a consumer is under the statute right now. It's being challenged, but traditionally it has meant paid for subscribers, right? So in the context of a streamer, that's pretty easy, right? You subscribe to Netflix, you pay money, you watch videos, yeah, you're a consumer. For things like insurers, who would that be? Maybe it would be people that were actually policyholders that pay a premium, certainly. But anyone else just coming to the site, wandering through to watch video, maybe not.
Okay. Yeah, that makes a lot of sense. So it sounds like the main concern is just the cost of this litigation for insurers, but it's definitely something that is important for them to be paying attention to.
Well, it's the cost and the indemnity obligations as well. From an insurance perspective, these cases have traditionally been handled under media policies, right? And over the last decade, so this is at least the second, if not the third wave of VPPA suits using different technology. Every time there's a technology change with cookies, you usually see the VPPA being challenged. And so a lot of media policies included exclusions which may exclude VPPA or mass privacy events, such as these kind of claims. But cyber policies, which were really at the forefront, like they're just getting started during that first wave of litigation. Most of these claims are being pushed to cyber policies. So if anything, it's the cyber policies really that are at risk for these.
Okay, yeah, that's interesting. And, I know you mentioned at the beginning of the conversation that the VPPA was originally enacted because, as you said, video rentals. But now a lot of the focus is on, these websites that collect data through cookies. And I feel like, I was reading that cookies have been around since the 90s, but it seems like recently we've become much more aware of their use. And I was wondering why that is. I know that a lot of websites are now asking permission for using cookies. Is that enough to avoid, some of these alleged violations, or should they be doing more?
It can be. So interestingly enough, you mentioned that the cookies have been around since the 90s. There was an original series of VPPA claims back in the early 2000s that literally dealt with, maybe it was the mid 2000s, that dealt with cookies and how the VPPA. And one of the biggest cases was against Hulu, which managed to defeat it. But like every time that cookie technology changes, and right now, Facebook Pixel is a new way of implementing cookies, right? So the technology has evolved, whereas in the past, cookie technology would literally just pull some information, but it may not share it. It would essentially pull the information for use by the actual website owner, but it might not get shared. And so now you have seen like the Facebook Pixel. There are other ad technologies out there. There are some different types of services that Facebook and Google Analytics offer, which are very cookie-like, which really have a lot of communication ability between multiple parties. And so I think every time that you see a new technology that allows the collection and sharing of information, you have the plaintiff's bar ready to make challenges to that technology if there are not real disclosures around that. And so you mentioned the new pop-ups, right? You're seeing a lot of pop-ups saying, here are our consents and our disclosures, and do you and yeah, those are relatively new, especially in the United States. And most of that is coming through, I won't say the VPPA litigation specifically. There is a host of other cases out there which are they're claiming that the Facebook Pixel violates wiretap statutes, like state wiretap statutes, like the California Invasion of Privacy Act, which essentially makes it illegal for any party to a communication to not know who else is on the communication, right? You have to disclose that. I'm being very general with the statute, but essentially the way to avoid problems, both with the VPPA and these wiretap statutes, is to provide notice, disclosures, and get consent before there's an interaction with the website. Now, if you ever visit any country in Europe, right, this has been going on for years because of the GDPR, the General Data Protection Regulations in Europe, have required something like this for a number of years. So at least in that part of the world, right, if you ever visit a website that's hosted from that part of the world, you've been seeing these for a long time.
Okay, yeah, that makes a lot of sense. And, this has been a really helpful conversation in understanding some of the things that are going on recently with the VPPA. So kind of given everything that we've talked about, what's your best advice for companies and consumers to, improve their privacy practices and make sure they're in compliance? And also, what should insurers be thinking about regarding all of this?
So in terms of what companies can do to be proactive, that's a really interesting question, because when you look at how many people have gotten hit with these suits, it's not small players. It's really large companies mostly that have very robust security protocols and compliance procedures. And what we have seen, at least, I think the market is seeing, is that there was just an escape of communication between marketing departments, the technology departments, and legal departments. So the Facebook Pixel was usually employed and deployed by marketing departments who were approached by retailers of these pixels and saying, if you use this, you can get great results on your marketing campaigns. And so they took it, and they didn't realize that they were actually collecting and sharing information in a way that created legal obligations. And so they didn't hand it off to their legal departments to say, can you vet this for compliance to see if we're in compliance with security privacy laws? And that just didn't happen. So I think one of the best things you can do is that companies should be requiring all three of those departments to get together whenever there are changes to a website, right? So if a website is using any new tools, somebody from IT or dedicated technologists should be saying, all right, if these tools share information or collect information, Are we in compliance? Hand that over to legal. Say, this is what it's doing, right? The IT department can say, this is what it's doing. And then legal can figure out a way to see if it's compliant and how to make changes if it needs to. And one of those things it can do is to create those pop-ups, right? And I think that's kind of a double-edged sword, right? So I'm a big fan and proponent of those if they're done correctly, because it takes literally 2 seconds. Most people just click right through them. A lot of companies that are sales-based do not like to put those on the websites because they see those as impediments to sales or impediments to interactions with the website itself. But at the same time, you need those disclosures up front and the consents up front before there's an interaction with the site. There's been a recent ruling which says that you can't obtain those consents after the fact, right? So it's not like if you went through this and you saw a video and that video got shared, and then at the end of the day, somebody said, oh, is it okay if this was shared, and you hit yes, that's not valid. There are very specific requirements with the VPPA's disclosure. And I'll just mention them briefly. One of those requirements is that the disclosure has to be separate from any other disclosure or notice that places a financial or legal burden upon the consumer, right? So if you embed it in your privacy policies, if you embed it in your subscription agreement, it may not be a valid disclosure under the VPPA. So I think one of the things that companies really should be looking at is if they are using disclosures and consents, that they should be getting those reviewed by outside counsel to make sure that they are, in fact, in compliance with the law. Another thing to do is to just retain or outsource electronic marketing and metric facilities, right? There are other companies that essentially will do this for you, right? They will design campaigns and collect the metrics around, what you want to do with your marketing. And then you can essentially shift liability to them in contract, right? That's another way that you can, pass the liability to a third party. And obviously, the last one is you should make sure that you've got insurance for this if you're undertaking these risks, right? And making sure that your insurance tower is appropriate for the amount of exposure that can be generated from these statutes, which is significant.
Yeah, that makes sense. That's all great advice for companies, and definitely insurance is an important piece of the, protection puzzle. So I think, this is an evolving space. I'm looking forward to seeing, where it goes and continuing to follow it. But this has been a really helpful conversation about what's, going on right now. So thank you so much for taking the time.
Oh, you're welcome. Thanks for having me.
Tony had a lot of great advice for businesses streaming videos on their websites about how they can keep consumer information safe. My next guest shared her best advice as well. I spoke next with Odia Kagan, partner and chair of GDPR compliance and international privacy at law firm Fox Rothschild. Over the past few years, Odia has assisted more than 80 companies, from US-based multinationals to startups, on their path to compliance with the EU's General Data Protection Regulation, or GDPR. She works to combine her knowledge of privacy and data security regulations with her understanding of emerging technologies to provide her clients with advice on how to design and implement their products and services, how to complete their M&A transactions, and how to engage third-party vendors in the US and abroad. She's particularly skilled at breaking everything down into easy-to-understand terms. She even has a newsletter called Privacy FOMO where she does this, and I definitely appreciated it as I was talking to her. We spoke about how data collection practices at companies may need to change as a result of the wave of VPPA litigation, and some of the challenges with using traditional legislation like this to litigate modern technology and data privacy issues. Here's what she had to say. Hi, Odia. It's great to be speaking with you today. How are you doing?
I'm fine, thank you. It's nice to be here.
Yeah, thanks so much for taking the time. I know that we're talking today about some of the litigation that's resulted from alleged violations of the Video Privacy Protection Act. But before that, I was wondering if you could just sort of give an overview of your background and the focus of your practice at Fox Rothschild.
Yeah, so my title is that I'm partner and chair of GDPR compliance and international privacy. And I actually do a fair amount of, so first of all, my practice is basically 100% privacy compliance with, now I have to say, I guess, privacy and AI compliance, and especially on the overlap with data protection. That sounds a lot more boring than it is, because I think it's, the best thing ever. But basically, compliance means that I help companies look at their products and services that leverage personal information, and now, increasingly also non-personal information, figure out which relevant laws, regulation, enforcement actually applies to what they do. And then, and this is kind of the best part, kind of break down the legalese in those laws to tell companies what are they supposed to be doing in order to comply, and even maybe more importantly, what is coming down the pike in, what are the trends, what are we seeing in the privacy tea leaves, so that they can get ready for. So basically that means that because privacy is a highly dynamic, that means that I spend a lot of time understanding what is going on, what is about to go on, and use that to inform my clients and inform my advice. And I sort of call it, hashtag privacy FOMO. So I have a lot of content on LinkedIn and Twitter, and I have a newsletter called Privacy FOMO to, inform clients and inform the public about what is going on and what needs to be done.
I love that, privacy FOMO. That's such a good title. And
thank you.
It's so funny because whenever I tell people I'm a cybersecurity and insurance journalist, they think it sounds boring too, but I'm like, no, it's really a fascinating industry. So I'm really looking forward to talking to you about all of this. And I know there's been sort of this wave of litigation regarding the VPPA recently. I was wondering if you could just talk about what led to this recent litigation.
So what I think is happening, and we'll talk about this more, I think, later, but, there is a lot of activity on the privacy side, right? We see a lot of new laws, a lot of new state laws, a lot of new work on the federal side. But really, for a long time, the U.S. either was or was deemed to be kind of behind on data protection regulation. And we know, of course, that Europe still regards the U.S. as not adequately protecting data of their individuals, right? We saw the big $1.3 billion Meta case from a couple of weeks ago. And so with that sort of, let's call it regulatory vacuum, and together with a lot of things that happened to increase the awareness of people in the US of what the right to informational privacy means, I think that sort of heightened the vacuum and the need for resolution, right? So for the longest time, and I'm talking, until up to, 5 years ago or something, I was teaching a class at a law school, and it was asking the students what they think privacy is. And almost everybody was talking about the interference of government in your daily life. And if you're not talking about that, you're thinking, bodily privacy. And we see that a lot right now after, the Dobbs decision. But the idea that informational privacy is a thing, I think started really ramping up after the Facebook Cambridge Analytica story. And so people started having much more concern with respect to what is happening with their data online, and a lot more awareness. And I think potentially maybe the pandemic contributed to that. Suddenly people that weren't online because they didn't need to are now online, and a lot of companies are getting their hands in, your data pie. So all of that, it's like, okay, my data's everywhere. I don't really have control over that. Things can happen when companies have my data, and I don't have recourse because we don't have laws. And, a couple of years ago, we really didn't. Now we went from 0 to 11 in a couple of years, but still we don't have a federal law. So there are most states that don't have that. And so all of that basically led where there's I remember my seventh grade science teacher telling us in Latin that necessity is the mother of invention, right? So the necessity is, okay, we have rights, and we have harms that need rectification, and we don't have normal recourse like a comprehensive privacy law like GDPR. So plaintiffs' attorneys have been finding, sort of new ways to utilize old laws in order to achieve that purpose. I think that is the biggest reason that I think. And the other is sort of concurrently the FTC, the Federal Trade Commission, which is the de facto privacy enforcer in the US that has been enforcing under the FTC Act, which is, a very old law, but has increasingly in the past, decade or so been enforcing more with respect to privacy. That also contributed to that because the FTC Act is an act that there are corollaries and parallels to it in the state laws. And so I think those are the two kind of currents that led to this wave of litigation. I mean, that sort of led to the beginning of the wave. The wave became a wave because, people are doing it, and therefore, hey, let's also try, right?
Yeah, that makes sense. That's really helpful background. And you mentioned a couple of points that I definitely want to get back to a little later in our conversation, but I think that makes a lot of sense, especially since the pandemic with a lot of companies embracing more technology as they switch to remote. So I was curious, how you expect data collection and transparency practices at companies to maybe change as a result of what they're seeing with this recent litigation.
So I think there are a bunch of things that need to happen. I think the first thing that, and I want to phrase this kind of as, rather than predictions, more like, suggested courses of action or kind of, practice points. First of all, I think that both because of this, but also because of other things that are happening concurrently, even, most notably like the Meta decision from a couple of weeks ago, the TikTok decision in the UK from a couple of weeks ago, the Spotify enforcement by the Swedish authority from like 2 days ago, right? They are all either centered on or concerned with, to a great extent, transparency. And so I think we also on the US side need to understand that transparency should be prioritized. It is a priority because it's like, what's the metaphor that I can use? It's like, it's like a tsunami, right? Like it's not here. We kind of see it on the horizon because we see it in Europe and we see it in other places, but the weather conditions are the same, right? So we have the same laws. They're just coming into effect. They have the same language. They have the same requirements. We are already seeing really serious enforcement in the EU. This is coming to us as well, right? So the first thing is kind of prioritize the transparency. And what does that mean, right? When you know that you need to do something and you think, oh, wow, I want to, be fit. And you're just thinking about, wow, fitness, that really doesn't give you a six pack, right? So what do you actually need to do once you know that this is something that you are prioritizing? The first thing you need to do is you really need to understand, and this sort of sounds cliche, but you really need to know what data is involved. Now, that seems a cliche because every single, privacy professional and compliance professional says that, but it doesn't mean what you think it means, right? I'm going to keep using the fitness and the calories metaphor, right? Like, where are the hidden calories in personal data, right? In this situation, it's the marketing piece that people have traditionally not thought about. So the trackers that are being used in websites, and what are they collecting and who are they sharing with, and what is the potential harm associated with it? All of that is now getting a huge spotlight, both under VPPA, but also the FTC enforcement and other litigation. So you need to figure out what personal information are you collecting, including in, your tracking activities, your marketing activities, your lead generation, your social media presence, right? Because, cookie ID and device identifier and the segmentation and attributes and event names that traditionally, really nobody cared about, are actually not only personal information, but they could be sensitive personal information. So first of all, you need to understand what is happening, not only what is happening in your organization, but also what your service providers are doing and what your third parties are doing. If you are sharing information with Meta or Google or whomever, you need to know what that information is that is being shared and what are they doing with it. And that was specifically mentioned in a number of the recent FTC decisions like BetterHelp and GoodRx and Easy Healthcare. So first of all, know what is the data, what are you doing, what everybody is doing it. Once you know, you need to ask yourself a serious question. Do I really need this? It's like I ask my kids, guys, do you really need that slushie? Like, you're going to have ice cream later. Do you really need the slushie? So, data minimization, right? Do you really need this tracker? I mean, it's there and sometimes it's free, but they were giving it to me in the birthday party. Okay, well, do you really need it? Why? Because all of the laws, the new ones in the States, require data minimization, meaning only collect that which you need for the purpose. Also, the FTC is saying that. So first of all, do you really need it? If you don't need it, kill it. Don't use it. Once you are limiting yourself to those that you need to do transparency well. You cannot hide behind vagueness. You can't use may. You can't say, oh, well, I might want to do that 2 years from now. So why don't I do it? Why don't I disclose it anyway? It doesn't help, right? You need to be specific. In the new TikTok decision, in the Spotify decision, it's very clear that you need to be very clear about the information disclosure. You need to say, what are you collecting, for what purpose, and who are you sharing it with, and how long are you retaining it? And you can't have these like long bullet point lists of here's what we're collecting, here's why, and you figure it out yourself. You can't do that. And finally, you need to give people control and choice over some of the information collection and sharing. And that is like, what is the choice is something that is becoming clearer. That is actually something that's interesting because to my knowledge, the VPPA litigation has not really been granular as to the type of consent that needs to happen in many cases because there was no disclosure or consent at all. And so when there is no disclosure or consent, you're like, well, there was nothing here at all. Obviously, that doesn't qualify. And there has not been in-depth litigation with respect to how and what type of consent. Is it really a true opt-in consent? The law says it needs to be in a form distinct and separate from any form, and setting forth the consumer needs to be at the election of the consumer. It needs to be just in time. It needs to be given in advance. It needs to be clear and conspicuous. So all of that stuff, I anticipate that there will be more discussion about, but it's clear that you need to give choice and control to the individuals with respect to the sharing of the information.
Yeah, I think that's all great advice for companies and consumers as well. And I love the fitness metaphor that you weave throughout your answer. It's true that thinking about fitness doesn't, in fact, give you a six-pack, which is unfortunate. But I think that's a great example of, moving beyond talking and thinking about it and actually taking action. So that's great. And I know you mentioned this earlier in our conversation. You also spoke about it in a recent Bloomberg article that there are plaintiffs' counsels that are using sort of traditional laws to litigate some of these modern privacy issues, since there isn't really any federal consumer privacy legislation. I was curious if there are any challenges with using those sort of traditional causes of action for issues like this.
So I think that the main challenge is that it is the certainty piece is difficult. There's no legal certainty. When you have litigation with a law that has traditionally not been used in a certain way, you don't know how the decisions are going to shake out. The fact that this is going on in different courts and different circuits, and the circuits are kind of, there's certain issues of first impression and deciding differently. It leads to a lot of lack of certainty for companies, right? Like, for example, in the VPPA, right, you have questions like, is this PII, right? Is it really information which identifies a person, right? Like, is the tracker, because traditionally, this is, right, VPPA, right? Which is why we're gathered here, right? This started as like a, video VHS rental law, right? So there was some sort of probably like, DOS database or like handwritten notebook in the store of like your name and like account number and which movies you have rented. So it was definitely tied to a name, probably to an address, probably to an account. Whereas the VPPA, the pixel, the trackers, they are tied to, I don't know, a cookie identifier, a device identifier. So is that PII? Is it a knowing disclosure? Are you really a videotape service provider? Because you're not, you're a website that happens to have a video on the website. Is the person visiting a consumer, right? You go into your video rental store, you're definitely a consumer. You're going into a website that happens to have a video, are you? Right? And so like all of these issues for VPPA are concurrently under discussion, right? In parallel circuits, and maybe not consistent, maybe difficult to follow, right? And then another word on like, and the same thing with respect to the other litigation, which I think we're going to talk about next, but also, the FTC, which is enforcing this particular issue of the lack of certainty in how to operate, has been a traditional complaint against the FTC. Right? It's like, okay, you guys are saying this is unfair and deceptive, but like, how was I supposed to know that? And so that has, because of that, we have seen, and, obviously there's discussion going both ways about this as well, but we have seen in the past few years, a big difference in the sense that the FTC has been giving proactive guidance. There are blog posts, there are events, the opinions are very detailed with a view to giving you some more, meat to form your compliance. And I think as a practice point, so that is what happens when you are using kind of a catch-all and an old law for new causes of action. Obviously, new same cause of action, new fact patterns. I think the certainty will keep increasing, when we have more precedent. But what the practice point here is, I think you need to understand what the actual requirements of the law are, not just what did people actually get caught about, because they could still, you just don't know. And then figure out what is your, risk tolerance based on that. So like understand what can you do that will absolutely be compliant? Can you do that? What are the costs of doing it? And if you can't, how do you mitigate your risk as much as possible and get close to it?
Yeah, that makes a lot of sense. And you mentioned that the FTC has been issuing a little bit more guidance on this, so we'll probably have more clarity going forward. I know it's tough to predict the future, but do you expect any action regarding a federal consumer privacy law, to emerge in the future?
I mean, in the future, yes. And I certainly hope so. And at least there's word, and I've seen a lot of writing about, the AI regulation is going to come faster than the privacy regulation. I think, so what we're seeing is the FTC is working on rulemaking. We are also seeing now I think we have, we can call it 11 or 10 and a half state laws, right? This time last year, we had 5. Now we have 11. My kind of personal theory / wishful thinking is, I call it the Big Bang Theory of ADPPA, that maybe there are a number of factors that are working in different currents that are going to come together and, create the Big Bang of ADPPA and revive, right? ADPPA is the federal privacy bill, bipartisan, that reached the House floor, but then died last year. And the currents are the number one, the increasing number of state laws. We have 10 on the books, plus Washington, My Health, My Data, plus another 20 something bills, right? We have a lot of post-Dobbs pressure, right? Because of the decision, there's a lot of pressure with respect to health-related laws. We have actually the AI pressure on AI regulation, even though that might actually lead to its own regulation with setting privacy aside. And then the FTC, right? There are a lot of voices on the Hill that are not comfortable with the FTC, the way the FTC is enforcing without a detailed law authorizing it. So it's acting under Article 5 of the FTC Act. And there are some people in Congress that would like to have a more set law. And the ADPPA, which appoints the FTC as the enforcement authority under it, the federal privacy enforcer, is going to give that certainty. So, on the flip side, election year and things. And so we will see, that I'm not a big, physicist. So I don't know how unlikely the Big Bang was until it finally happened. But, I can hope at least.
Yeah, I think that makes sense. There's definitely a lot going on right now, so it'll be interesting to see what happens in the future. And, one last question I wanted to ask you is, I know that you've spoken about how some of these recent class actions regarding the VPPA have joined other, creative emerging class action trends. So I was wondering if you could talk about some of these other trends and, what we should be paying attention to right now.
Yeah, so there's three kind of streams, right? One is BIPA, the Biometric Information Protection Law of Illinois, which talks about biometrics. This one it's an old law. I think it's like 2003, I think. And it used to mostly be centered around, biometric time entry clocks for employees. And because of the changing uses of biometrics, now we have, face scans and eye scans and palm scans and voice recognition and gait analysis and selfie and video uploads to analyze things. And because of that, there is a lot of litigation and enforcement concerning biometrics. So this is both under Illinois, Texas, and also the FTC just recently published a number of a blog with respect to enforcement in biometrics, as well as the two decisions in connection with Amazon, Ring and Alexa, talking about voice recognition and video analysis. And so biometrics is one. The other is a lot of so basically the overarching point is trackers and pixels as good old wiretapping, right? When you are, collecting information through a pixel unbeknownst to me, is that just like good old wiretapping of my phone conversation? This also applies to chat recording. So we have a ton of chat bots. If you are recording your chat, that can be wiretapping because you don't have two-party consent. So you need consent of the individual. Session replay, which is basically a way through a JavaScript to basically track actions on the website, mouse clicks, heat maps, movements, finger swipes, etc. That is also the subject of kind of wiretapping litigation. And then generally pixels and trackers being, as we mentioned before, unfair or deceptive under, either the FTC Act or the baby FTCs, right? Like the parallel state consumer protection acts, meaning the argument here is, you're sharing information through these trackers, you're sharing them with third parties who are using them for their own purposes. I, the individual, had no idea this is happening. That's not fair. And that's misleading to me because you're sharing information. So those are kind of the three big: biometrics, wiretapping, and deceptive and unfair.
Awesome. Yeah, that's a great overview of some of the stuff that's going on right now. There's so much. You mentioned these emerging class action trends. You also mentioned AI and, the Dobbs decision. I feel like we could go on and on, but, conversations like this really help me wrap my mind around it. And I'm sure all of our listeners as well. So thank you so much for taking the time today.
Yeah, absolutely.
Well, that's it for this episode. Thanks so much to Tony and Odia for taking the time to speak with me, and thanks to all of you for listening. Once again, my name's Elizabeth Blossfield, and I'm the host of the Insuring Cyber Podcast, a bi-monthly look into how the world of cyber and the business of insurance are connected. Be sure to check back for new episodes of this podcast, publishing every other Wednesday, wherever you get your podcasts. Talk to you next time.